Hello, ladies and gentlemen. Is there anybody here? I'm Edward, lawyer of Shaw and Kim Law Firm in China. I come here to give you free legal advice on your business related to China law. This is the first time I come here, and I do not know this software so well, and so I do not know how to display my materials.来，
是的，是这，请你不要看一下。
写吧，就那样子。
然后那个张嘉文又在说我们这边有什么对策，要打算怎么办啊什么的。
你考虑一下吧。你说他自己可以投诉，律师尽量不投诉。他自己作为当事人，他投诉是没有风险的。
对，然后他说要证明漏水问题嘛，我说这个已经在那个
证明漏水问题，我们那个视频里面已经很清楚了。
对，而且那个判决书也确认了，但是他的意思就是说，那个法官的话，他说要不要提供证人啊什么再去证明，我说其实不用，但是他说
其实不用的。
对呀，然后
其实根本不用的。
对，但是他就说认为那个法官很不公平，他想提供一些更确凿的、无法反驳的那些东西，他自己考虑很多。
那个位置，那个视频，它是一个视频，视频里是有位置的，是能看得出来的。
是啊，
甚至可以到现场去检验的。
对呀，其实我们在那个案件中也是提供这些，然后这么说，对吧？那法院才最终确认的。
对呀，而且那个原来的那个案件，那个判决里面是确认了漏水这个事实的。
是啊。
确认漏水这个事实。
确认这个事实，同时确认是905。
是啊。但是他现在想否定，那是不对的吧？
是啊。然后
你这个主要的内容是什么？你这个质证意见？
主要就是说，首先我们并不是转租，他就是将实际经营或控制的公司转入905，是符合合同约定的，是办公之用。只不过第一次我们是以实际办公的公司的名义起诉。因为我们还要主张公司的经济损失啊这些，所以用这个公司才名正言顺。但是法官认为主体不适格，才用法拍名义重新起诉。这么解释。
那你那个不适格，这个也不适格，那谁适格？
是啊，
是不是？
然后我把那个笔录拍了照之后才想起说，原来对方对我们质证的意见，法官也没有告诉我们他质证什么，直接跳到我们要质证对方了，就只有法院知道对方质证什么，我们就根本无法反驳。 就看了笔录，我才知道哦，原来对方说的这些。
那我们就全都是
对，法官
那个书面的，
对，他们就不给我们反驳和说话的机会，看都不给我们看。
行，把这个也做个记录，我们这个二审的时候可能要说这个问题。And first of all, as this is the first time I come to make a speech about on this YouTube, I'll give a brief introduction to my law firm. Oh, excuse me. This is the wrong document. Shaw & Team Law Firm. I am the director of this law firm. I am Edward Shaw. The address of my law firm is apartment 1401 of A Building, Vanke Financial Center, number 55, Jihua Road 5, Chengcheng District, Foshan, China. As a major legal service provider for foreigners and foreign enterprises in Guangdong province of China, Shaw & Team Law Firm focuses its major efforts on international legal service. Our service covers international trade, investment, and intellectual property protection. Shaw & Team Law Firm teams up 20 lawyers with long-time international legal service experience, and that our working language is English and Chinese. Shaw & Team Law Firm and all its lawyers will always work with our best effort for our clients' legitimate rights, providing professional, quality, and satisfactory service. Shaw & Team Law Firm. As a major legal service provider for foreigners and foreign enterprises in Guangdong province of China, Shaw & Team Law Firm focuses its major efforts on international legal service. Our service covers international trade, investment, and intellectual property. Shaw & Team Law Firm teams up 20 lawyers with long-time international legal service experience, and that our working language is English and Chinese. Shaw & Team Law Firm and all its lawyers will always work with our best effort for our clients' legitimate rights, providing professional, quality, and satisfactory service. And then now I hereby introduce a new legal service. And this is new. Okay, excuse me. Hi, this is Edward, lawyer and director of Shaw & Team Law Firm. As a major international legal service provider and trade protector, Shaw & Team Law Firm mainly serves for purchasers from around the globe, and hence during this pandemic of COVID-19, we hereby offer you a new service. Here follows. First, a retainer contract of perennial legal counsel will be signed for you to hire 13 lawyers of Shaw & Team Law Firm as your legal counsels. Second, as your legal counsel, 1 or 2 Shaw & Team Law Firm lawyers will be sent to represent you in contacting and negotiating with Chinese suppliers. Third, upon negotiations, we will draft a contract for the transaction, and with your authorization, 1 S&T lawyer will sign the contract on behalf of you. 4, in this contract, the place of signature will be the place of S&T domicile. Hence, the court of jurisdiction shall be the one at S&T domicile. 5, in this contract, the burden to prove quality compliance shall be borne by the supplier. 6, with the above law tactics and others, your business relating to China and Chinese suppliers will be absolutely safe. I'll say it once again. Hi, this is Edward Shaw, a lawyer and director of Shaw & Team Law Firm in China. As a major international legal service provider and trade protector, Shaw & Team Law Firm mainly serves for purchasers around the globe, and hence during this pandemic of COVID-19, we hereby offer to you a new service. Here follows. First, a retainer contract of a perennial legal service, legal counsel. A retainer contract of perennial legal counsel will be signed for you to hire 13 lawyers of Shaw & Team as your legal counsels. Second, as your legal counsel, 1 or 2 S&T lawyers will be sent to you in contacting and negotiating with Chinese suppliers. Third, upon negotiations, we will draft a contract for the transaction, and with your authorization, 1 S&T lawyer will sign the contract on behalf of you. Fourth, in this contract, the place of signature will be the place of S&T domicile. Hence, the court of jurisdiction shall be the one at S&T domicile. And in this contract, that is the 5th point, in this contract, the burden to prove quality compliance will be borne by the supplier. And sixth, with the above law techniques and others, your business relating to China and Chinese suppliers will be absolutely safe. And hence, the seventh, your expenses of traveling to China or establishing an office here will be saved, and your risk relating to quality compliance will be erased. And the next issue we are to talk about is 28 questions on arbitration law of China. Good morning, ladies and gentlemen. Today we are to discuss about the arbitration law of the People's Republic of China. In order to grasp the Chinese arbitration law, we are to answer the following questions. The first question is, what subject issues can be arbitrated? The first condition is that there should be a contract, and that is to say the subject issue should be a dispute on contract. That is, the disputes over contract. Second, this contract shall be on property rights and property interest. Third, the dispute should be between parties of equal status, i.e., natural persons, legal persons, and other organizations who are deemed equal by law. That is, disputes between citizens, legal persons, and other organizations of equal footing. Fourthly, there should be an agreement for arbitration in the contract. That is, the agreement of arbitration. So, in general, a subject issue that can be arbitrated should be a matter in contract with an arbitration agreement, which is agreed on subject matters of property rights or property interest between parties of equal status. And the second question, what subject issues cannot be arbitrated? In Chinese law, we have a habitual practice. That is, we normally prescribe what is not something after we prescribe what is something. Here we also have this practice. Right after what we can be arbitrated, we list the subject issues that cannot be arbitrated. So What are the subject issues that cannot be arbitrated? Firstly, kinship issues. That is, disputes over marriage, adoption, guardianship, children maintenance, and inheritance. Those issues concerning family relations cannot be arbitrated. And secondly, disputes related to administrative conduct cannot be arbitrated. Generally, such administrative disputes will fall within the jurisdiction of the relevant administrative agencies, i.e., to be solved by a government agency of a higher level, and then go directly to courts of jurisdiction for administrative litigation. So, disputes over administrative conduct cannot be arbitrated. Thirdly, after the enforcement of labor contract law in 2008, a special arbitration proceeding for labor law disputes was set up. So, labor law disputes cannot be arbitrated according to the arbitration law we talk about here. And here, the third question. What is a valid arbitration agreement? Just now we mentioned the law requires a valid agreement for arbitration to access the arbitration proceedings. Then, what is a valid arbitration agreement? The law requires that the arbitration agreement should be reached on a voluntary basis. The arbitration, and just now we just talked about those issues that cannot be arbitrated, okay? And the arbitration agreement should be in writing. The Chinese law requires that the arbitration agreement should be in writing. And then in this agreement, there should be a manifestation of willingness to reach the agreement and the willingness to be bound to by the award concluded by the agreed arbitration commission. And the arbitration agreement can be concluded before or after the arising of the dispute. Anyway, before the arbitration procedure. As contrary to what is valid arbitration agreement, we also have the question of what is not a valid arbitration agreement. The arbitration agreement is valid when the subject issues falls beyond the scope of prescribed by the Chinese arbitration law. The party in entering into the agreement is lack of capacity of conduct. And the next, the party was forced to enter into the agreement. That is what we say in a law, word of law, that is duress. And this is a like of subject issue in the agreement. And of course, when it is not mentioned what subject issue can be arbitrated, and of course they can replenish it before the arbitration procedure. And the arbitration agreement can be invalid when there is lack of specific arbitration commission. That is, we have to mention the arbitration commission. We should have a name of the arbitration institution. Of course, this can be replenished before the arbitration proceedings. And the fifth question, when and where to make the objection against the validity of the arbitration agreement. In case the arbitration agreement fall into the above-mentioned invalidity situations, the respondent will have the right to challenge the validity of the arbitration agreement. He may assert a statement at the arbitration commission or start a litigation action at the court to claim the invalidity of the agreement before the first arbitration hearing or within the time limit prescribed by the arbitration rules. In case the application applies for arbitration, the respondent challenges the validity at the court's ruling will prevail. The sixth question: what documents should be submitted to apply for arbitration proceeding? In applying for an arbitration proceedings, you've got to submit the following documents. The first one is application. That is the major document in which you have the content of claim and the argument, facts and arguments. The second document is document of arbitration agreement. The third document is document of applicant's identity with service address. Fourth, document of respondent's identity with his service address. And fifth, you've got to have evidences. And it is always the case that you've got to attach a list of the evidences with the evidence. And the sixth, witness identity document and service address. The seventh question: what should be the application contain? Just now we mentioned the application is the major document you submit to the arbitration commission, in which you've got to have your claim, facts and argument in it. Yeah, and so here we talk about what should be contained, what should be written in this document. First of all, the identity of the applicant. Second, identity of the respondent. Third, the claim. Fourth, statement of facts and argument. The eighth question: what time should the commission accept or reject? The arbitration commission should serve on the applicant a notification of acceptance or statement of rejection 5 days upon receipt of the documents submitted. Ninth question: how the service will be conducted? In case of acceptance, within time limit prescribed by the rules, the commission should serve on the applicant the rules and list of arbitrators, on the respondent a copy of application, rules and list of arbitrators. 10th question: how the respondent should respond. Upon receipt of the copy of application and list of arbitrators, the respondent shall, within time limits prescribed by the rules, submit its defense. Of course, the defense can be attached with a counterclaim to the arbitration commission. Hence, the arbitration commission shall, within time limit prescribed by the rules, serve a copy of the defense on the applicant. The failure of the respondent to submit a defense shall not affect the proceeding of the arbitration procedures. The 11th question: how to ensure that the applicant's claim be realized when he wins the case? In order to make sure that his claim be realized after proceedings, the applicant have the right to apply for property preservation. First, a party may apply to arrest the respondent's property for future enforcement. Second, the application for property preservation shall be submitted to the court of the basic level at the location of the property through the arbitration commission. And third, the court will require guarantee for property preservation. And the fourth, the guarantee should be either property of equal value or letter of guarantee of equal value issued by an insurance company. And of course, the desired arrested value shall not be less than 50 of the claimed value. The 12th question, how to save important evidences from being destroyed. In the event that the evidence might be destroyed, or if it would be difficult to obtain the evidence later on, the parties may apply for the evidence to be preserved. If the parties apply for such preservation, the arbitration commission shall submit the application to the basic level court of the place where the evidence is located. The 13th question, how is an arbitration tribunal formulated? An arbitration tribunal may comprise 3 arbitrators or 1 arbitrator. Among the 3 arbitrators, there should be 1 presiding arbitrator. Whether the tribunal comprise 1 or 3 arbitrators should be agreed by both parties. In case of 3 arbitrators in the arbitration tribunal, each party shall select or authorize the chairman to select 1 arbitrator. And the 3rd arbitrator should be selected by both parties jointly or appointed by the chairman, and the arbitrator thus selected shall be presiding. In case of single arbitrator, the arbitrator should be selected by both parties jointly or appointed by the chairman. Failure of selecting the formation and arbitrators will incur appointment by the chairman. That is to say, when both parties of the arbitration agreement fail to select their own arbitrator or the formation of the arbitration tribunal, the chairman of the arbitration commission shall make a decision. That is the appointment by the chairman. Upon establishment of the arbitration tribunal, a notice in writing of the formation of the tribunal shall be served on both the applicant and the respondent. After the arbitration tribunal is constituted, the arbitration commission shall notify the parties in writing of the composition of the arbitration tribunal. The 14th question, in what circumstances an arbitrator should withdraw? An arbitrator should withdraw. Any party will have the right to apply for the arbitrator to withdraw in any situation. Here follows. First, the arbitrator is a party or a close relative of a party or of a party's representative. Second, the arbitrator is related in the case. Third, the arbitrator has some other relationship with the party to the case or with the party's agent, which could possibly affect the impartiality of the arbitration. And fourth, the arbitrator meets a party or his agent in private, accepts an invitation for dinner by a party or his representative, or accepts gifts presented by any of them. The 15th question: how to apply for an arbitrator to withdraw? When applying for the withdrawal of an arbitrator, the petitioning party shall state his ground and submit a withdrawal application before the first hearing. Second, a withdrawal application may also be submitted after the conclusion of the last hearing if the ground situation for the withdrawal only became known after the start of the first hearing. Whether an arbitrator is to withdraw or not shall be determined by the chairman of the arbitration commission. If the chairman is serving as an arbitrator, the withdrawal or not the issue of withdrawal or not shall be determined collectively by the arbitration commission. Fifth, if an arbitrator is unable to perform his duties as an arbitrator as a result of the withdrawal or any other reasons, another arbitrator shall be selected or appointed in accordance with the provisions of the arbitration law. The 16th question: how is the hearing proceeded? The hearing shall be held unless both parties apply for documentary trial. The hearing shall not be conducted in public unless both parties agree and the case is not related to the state secret. The application commission shall notify the two parties within the time limit provided by the arbitration rules of the date of the hearing and the place. Date and place of the hearing. When notified in writing, the applicant's absence without reasonable ground shall deem withdrawal. The respondent's such absence will incur absent trial. Each party should produce his own evidence in support of his claim and argument. The commission may collect evidence when it regards necessary. An appraisal may be conducted by the commission's nomination, and the appraiser shall present at the hearing when the arbitration tribunal deems necessary. The 17th question: how conciliation is valued by law and the procedure? An award can be made upon conciliation when the agreement is reached by both parties. A conciliation statement consists of settlement agreement will be the same effective as an award. The 18th question: what if there is different opinion on the arbitrators? The majority principle will apply. That is, an award shall be based on the opinion of the majority arbitrators. The opinion of the minority arbitrators shall be recorded in writing. In case no majority opinion can be reached, the presiding arbitrator's opinion shall prevail. The 19th question. What if some fact cannot be cleared? In such a case, partial award may be made upon the facts cleared. During the course of arbitration by an arbitration tribunal, where a part of facts has been made clear, a partial award may first be given in relation to that part of the facts. The 20th question. At what time the award will be effective? The commencement of the effectiveness shall be on the date of service. That is, an award shall be legally effective on the day it is served. As the arbitration award is made upon only one trial, and the award will be effective when it is served, if you don't accept such an award, you may claim at the court to challenge the effectiveness thereof and nullify the same. The 21st question. How to nullify an award made by an arbitration commission? The parties may apply to the intermediate court at the place where the arbitration commission is located for nullification of an award if they provide evidence proving that the award involves one of the following circumstances. First, there is no arbitration agreement between the parties. Second, the matters of the award are beyond the extent of the arbitration agreement or not within the jurisdiction of the arbitration commission. Third, the composition of the arbitration tribunal or the arbitration procedure is in contrary to the legal procedure. And fourth, the evidence on which the award is based is falsified. The other party has concealed evidence which is sufficient to affect the justice of the award. And sixth, the arbitrators have demanded or accepted bribes, committed graft, or perverted the law in making the arbitral award. Seventh, the People's Court shall rule to nullify the award if the existence of one of the circumstances prescribed in the preceding clause is confirmed by its collegiate bench. The eighth, the People's Court shall rule to cancel the award if it holds that the award is contrary to the social and public interest. The ninth, nullification in 6 months. If a party applies for cancellation of an award, the application shall be submitted within 6 months upon receipt of the award. The 10th, nullification judgment in 2 months. The People's Court shall, within 2 months upon receipt of the application of cancellation of an award, render its decision for cancellation of the award or for rejection of the application. 11. Re-arbitration. If the People's Court holds that the case may be re-arbitrated by the arbitration tribunal after accept the application for cancellation of an award, the court shall inform the arbitration tribunal of re-arbitrating the case within a certain period of time and rule to suspend the cancellation procedure. If the arbitration tribunal refuses to re-arbitrate, the People's Court shall rule to resume the cancellation procedure. While one party applies to the court for enforcement of the award, the court will examine and verify it. Then we have the 22nd question. In what situations the court will deny the enforcement of an arbitration award? If the party against whom the application is made furnishes proof that the arbitral award involves any of the following circumstances, the court shall, after examination and verification by a collegiate bench, make a written order not to allow the enforcement. First, the parties have had no arbitration clause in their contract, nor have subsequently reached a written agreement on arbitration. Second, the matters dealt with by the award fall outside the scope of arbitration agreement, are matters which the arbitral institution has no power to arbitrate. And the third, the composition of the arbitration tribunal, the procedure of arbitration contradicts the procedure prescribed by the law. And the fourth, the main evidence for ascertaining the facts is insufficient. And fifth, there is definite error in the application of the law, and or sixth, the arbitrators have committed embezzlement, accepted bribes, done malpractice for personal benefits, perverted the law in the arbitration of the case. And seventh, if the People's Court determines that the enforcement of the arbitral award is against the social public interest, it shall make an order not to allow the same. The 23rd question. How a court will deal with the competition between an application for enforcement and the application for nullification of the arbitral award. If one party applies for enforcement of an award, while the other party applies for cancellation of the award, the People's Court receiving such application shall rule to suspend enforcement of the award. If a court rules to nullify the award, it shall rule to terminate enforcement. If the court rules to deny the application for cancellation of the award, it shall rule to resume enforcement. The 24th question. Can a foreign element-related case be arbitrated in any of the arbitration institutes? First, foreign elements-related arbitration refers to the case in which the applicant, respondent, subject matter, evidence, etc. involves foreign people, foreign country, or foreign laws. It is prescribed by law that foreign elements-related arbitration should be conducted by a commission established for that purpose. China International Economic and Trade Arbitration Commission and its sub-commissions covers most territory of mainland China and plays the most important role. The 25th question. How is evidence preservation conducted in a foreign-related arbitration? This is different from the way adopted in other cases. In foreign-related arbitration case, evidence preservation should be applied at the intermediate court at the evidence location. The 26th question. How can an award involving foreign element be enforced? 1. The enforcement of an award involving foreign elements should be applied at the intermediate court at the domicile of the party subject to enforcement or at the property location of the same. Second, the intermediate court to which the enforcement is applied shall, after examination and verification of its collegiate bench, rule to nullify an award if a party to the case provides evidence proving that the arbitration award involves one of the circumstances prescribed in Article 274 of the Civil Procedure Law. Third, where the party subject to enforcement or its property is not within the territory of the People's Republic of China, a party applying for the enforcement of a legally effective arbitration award shall apply directly to the foreign court having jurisdiction for recognition and enforcement of the award. Fourth, an award should be applied for enforcement within 2 years, commencing from the next day of the last day of performance ruled by the award. The 27th question: what are the requirements for POA, that is, power of attorney, from abroad? First, a foreign party may hire a representative to participate in the proceedings. Second, a foreign representative without a Chinese lawyer's license will not be deemed as a lawyer. Third, a power of attorney signed by the natural person applicant or by the person who has the right to represent the legal person applicant should be submitted to the commission. Should be submitted to the commission. The person who has the right to sign the POA should be the legal representative of the legal person if the law of the origin has set a law regulation, and hence a certificate of legal representative should be issued by the legal person applicant. Otherwise, there should be an authorization for signature issued by the board of directors. Normally, most arbitration commission will also require that a resolution of board of directors to start the arbitration application should be submitted. The 28th question, that is the last question: what the Chinese law requires for authentication of evidence and power of attorney from abroad. First, the Chinese law requires that all evidence, including POA and documents of identities from abroad, should be authenticated by the Chinese consulate to that country. Second, before authentication at the Chinese consulate, such documents should be notarized by the local notary public or should go through other procedures prescribed by the law of the origin or by the bilateral treaties between China and that foreign country. Third, in case such documents are signed inside China, the signature should be either signed at a Chinese notary public or before the official of the commission. Fourth, all documents in a foreign language should be attached with a Chinese translation, and such translation should be made by a licensed translation company, and such translation should also be notarized by a notary public, either foreign or Chinese. That's all for today.